Defenses against negligence. Actual denial. Doctor denies his responsibility straight away and asserts that he discharged his duties according to the prevailing standard. His record should be proper and complete to prove his assertion. Calculated risk doctrine. Calculated risk doctrine of professional medical judgment, assert that doctor is not liable if he took a reasonable and calculated risk to save life of a patient and in the process suffered injury. And in the process, patient suffered injury. Silent features. Principle. Medical profession is a highly risk-prone area, and treatment often involves a calculated risk and a possible de-arrangement among experts as to whether the risk was warranted or not. If a physician chooses for a patient a course of treatment within a range of medically accepted choice after a proper examination and evaluation, the calculated risk doctrine will insulate him from liability. To impose liability, a plaintiff must show that the doctor's decision was something that fell below the certified medical determination. It is an important exception to the principle of res ipsa loquitur, since it covers inherent risk of a medical procedure or operation. What a doctor must prove? He must produce expert evidence or statistics that the line of treatment he chose was a medically acceptable procedure under the condition that it had unavoidable risk. Examples: adverse reaction to penicillin, streptomycin, IV antibiotics, immunization, all sorts of blood transfusion, Novocaine, X-ray, dye study, injection into the spinal canal, injection of gold for rheumatoid arthritis, and injection of cortisone directly into the joint. Case studies: Severs and Weber, 1962. Dr. Charles Weber, a gynecologist, performed hysterectomy on Leanne Stevenson. 10 days later, a vesicovaginal fistula developed. Stevenson brought a case of negligence against Weber, citing the doctrine of res ipsa loquitur. She asserted that she did not have to prove anything, merely the fact that hysterectomy was performed and that a fistula developed after that mean that the fact themselves spoke of negligence. The doctor, however, said that the fistula could occur even though the surgeon had experienced the care and skill generally possessed and exercised by reputable gynecologist and the development of a fistula, although rare, is considered as inherent risk of the operation. It was a calculated risk taken by the Dr. Weber case. Contributory negligence. Emergency. In an emergency, doctor may take some drastic measures to save life, which may cause injury. A fracture of rib during cardiac massage falls under calculated risk doctrine also. Law of limitations. Law of limitations specifies that a claim for compensation can be brought against a doctor within a specific period. If the claim is brought after that period, the doctor can take the defense of limitation. For cases related to Consumer Protection Act, the aggrieved patient must file a complaint within a period of 2 years of discovery of a alleged negligence. Next is medical misadventure or medical malaccurrence. No duty owed towards the patient. If the doctor had not agreed to treat patient, no duty existed. Novus actus intervenius. An unrelated act refers to a situation where the doctor has been negligent, but a completely unexpected and unforeseen act happened which further worsened the patient's condition. Silent features. The new act intervening should be completely unexpected and unforeseen, sometimes referred to as an act of God, breaks the chain of causation between the act of negligence and the resulting damage. Thus, injury no more remains a proximate cause of doctor's negligence. Then doctor's negligence, patient's negligence. Res judicata. Res judicata is a Latin term meaning the thing has been decided. Section 300 CRPC, also known as the doctrine of double jeopardy. If a situation of a negligence against a doctor has been decided in one court, a consumer court, the patient cannot start another proceeding in a different court. Appeal to the higher court, however, is allowed. Voluntary non-fit injuria. Voluntary non-fit injury, Latin. A willing person injury is not done. To a willing person injury is not done. A legal doctrine, which means that if someone willingly places himself in a position where harm might result, he will not be able to bring a claim against the other party. Silent features. For this claim to succeed, the doctor must show that an informed consent had been taken and all side effects had been experienced. Example: patient sustained radiation burns during therapy and he had earlier been explained about the risk. He cannot claim damages. Voluntary non-fit injuria. Res judicata, patient negligence. Novus actus intervenius. No duty owed towards the patient. Medical adventure. law of limitations, actual denial, calculated rescue, doctor right, and contributory negligence and emergency. Thank you.